Having talked now about some of the preliminary issues relating to contracts, and having talked about the process of putting together a contract, and having talked about some of the mistakes that might come up in the course of drafting a contract, now let's take this video, this probably the last video for chapter 13. Maybe I'll be wrong, but I think this this video will be the third and last for this chapter. Let's take the time and walk through the parts of a contract. And I am going to post, so by the time that you view this video, there should be posted to Canvas for this chapter a copy of a contract. And it will be it's a contract that I've drafted for a transaction. It's on the shorter side for my transactions. When I showed it to my class in the fall semester, and I said this was one of my shorter transactions, they were kind of astounded because it's maybe about 15 pages, but it's definitely one of the shorter ones. And what I will do in that contract is I will pick apart and show you the various parts that we're going to talk about tonight. It's a little hard in this format for me to pick apart the contract with you the way that I might if we were meeting in person. And maybe I'll discover a way to do this better the next time I teach this class online. But I will break up that contract for you, and I will identify the parts that we talk about tonight so that you can look at a real contract and see how these provisions that we talk about come into play with respect to real contracts. So the first thing that you will see when you look at a contract is the title. And usually it says agreement, it might say a type of agreement, it might say purchase and sale agreement, it might say transfer agreement, it might say lease agreement, it might just say agreement. But usually every contract has a title. It could be a one-word title, it could be a multiple-word title. It could be a title that describes the type of agreement. For instance, we did in the transaction, that joint venture transaction, we did a shareholders agreement among the shareholders in the joint venture entity. We did a share subscription agreement where each of the parties agreed to buy their particular shares in this joint venture company that was being created. And we also had a guarantee agreement because the parent company of my client was going to be guaranteeing certain obligations of my client to the joint venture firm. So there were various types of agreements, and the titles reflected what those agreement types were. After the title, the next thing that you will usually see in a contract is the introductory paragraph. And the introductory paragraph identifies who the parties are to the contract, usually identifies the date of the contract or the effective date of the contract, often will identify the nature of the contract, and might include some information about the reasons for the contract. And that introductory paragraph could become more an introduction and could include several different parts. It could include both the introductory paragraph and recitals. And recitals are, it's a fancy word for an explanation of where this contract is coming from. What is the nature of the underlying agreement between the parties? The recitals are generally not part of the contract, but they explain the contract. They're not part of the agreements between the parties to the contract, but they explain the nature of those agreements and explain where those agreements come from. And it usually also, the introduction to the contract usually includes language stating that the parties are agreeing and enter into this contract. And it also, the introduction will also include a recitation of what the consideration is between the parties. And if you remember back when we were talking about the elements of a contract, one of those elements is consideration. And oftentimes in a formal written agreement, the parties will recite what is the consideration that is passing between them. They may say it's the mutual promises that are set forth in the agreement, and that is valid consideration for a contract. It may say in exchange for value shown or value exchanged. That also would be a proper exchange, at least a proper description of consideration, and then it'll be up to the parties to actually exchange that value and establish that they had proper consideration. We will then, the next main part of a contract would be what is called a covenant. And a covenant is a promise. A covenant is a promise that a party makes in a contract. And most contracts have multiple covenants from one side to the other. One side agrees to do several things, the other side also agrees to do several things. Now, when we have covenants, if one party does not if one party does not do what that party has said that it would do, that party is then said to be in breach of the contract. And a material breach of the contract is a violation of the contract that basically goes to the essence of the contract and defeats the essential purposes of the contract. And in the event of a material breach, the non-breaching party is able to assert remedies against the breaching party. Covenants often require a party to act reasonably, or to either act reasonably in all circumstances or act reasonably with respect to a particular circumstance or a set of particular circumstances. What do we mean by reasonable? We basically mean that the party behaves in an ordinary and usual manner under all of the applicable circumstances. In contracts, with respect to covenants in particular, there is an underlying duty to act in good faith. There is an underlying duty of good faith and fair dealing in all contracts. And good faith is where the parties act in an honest effort to achieve both the letter and the spirit of the contract. Unless the parties specifically waive the covenant of good faith and the covenant of fair dealing, they are implied in every contract entered into under prevailing American law. Sometimes in a covenant, a party is allowed to make a decision based on a certain type of discretion. A party may be have the right to act or not act, or to consent or not consent to something. A party normally is expected to use reasonable discretion, which means usual and ordinary discretion. The discretion that a reasonable person would use under the circumstances. But sometimes, where matters are particularly important to a contract party, they require that the contract specifically allow them to act in their sole discretion. So the party would have the ability to act in its sole discretion, its arbitrary discretion. It could be arbitrary. It doesn't have to act in good faith. It doesn't have to act in fair dealing. It can act any way that it wants. If the parties have agreed to sole discretion, and if the parties have generally equal bargaining power, courts will allow sole discretion standards to be included in contracts. And you'll see reasonable discretion, sole discretion standards in the sample contract that I post to the Canvas site. There are various types of covenants that go into an agreement. There are what are called reciprocal promises. Those are promises that each party makes and that are enforceable independently. So a party can make a reciprocal promise is each party's promise, each party's covenant is independent of the other and can be enforced independently. Now, the opposite of reciprocal promises are what are called conditional promises. Those are promises that are based on conditions. Those are promises that the party agrees to perform only if the other party performs its obligation, what it has promised to do. So you have reciprocal obligations which are independent of each other and which can be enforced separately, or you have conditional promises which are contingent on each other, which are linked to each other, and one party is obligated to perform only if the other party does what it has promised to do as well. Now, the other main part of a contract, other than the covenants in the contract, are what are called the representations and warranties. Representations and warranties are statements of fact, past fact or present fact, on which the contract is based and on which the parties are agreeing to enter into this contract. They are not promises. They are not covenants. Covenants speak to the future. Covenants speak to what the parties are going to do as the contract progresses. Representations and warranties deal with the past and the present. They deal with conditions. They deal with circumstances that are important, that are the basis for the parties' agreement. Covenants are promises. Representations and warranties are statements. Those are the principal main parts of a contract. But there are other parts of a contract, and these other parts of the contract are very important parts of the contract, but they are often more they're often more traditional. Trying to come up with the right word. They are contract terms that are more usual and common and customary. They don't change as much as do the covenants and the representations and warranties in a contract. And most of these provisions are generally considered miscellaneous provisions. And they often have in the trade the common term of boilerplate. And people, even non-lawyers, often know and talk about boilerplate provisions to a contract. Where does that term boilerplate come from? It comes from the old days when contracts would be printed. And printers would have all of these provisions sort of pre-typefaced. So they didn't have to re-typeface these provisions for each contract that they would be printing. These provisions would be what are called boilerplate because they were there ready to be printed, inked up and printed. Whereas the provisions dealing with the covenants, the provisions dealing with the representations and warranties, they might have to change. So these provisions are provisions that don't generally change, that change much less frequently when parties are negotiating contracts. What are some of the type of boilerplate provisions? Well, we've met some of these already in some of our past discussions. Boilerplate provisions include choice of law. Which state or which country's law will govern the contract? Choice of forum provisions. If you remember, choice of forum is where the parties agree that disputes will be resolved, where any litigation would take place. It could be in a state court, a federal court, the courts of a foreign country. It could be alternative dispute resolution. It could say that disputes are going to be governed, are going to be resolved in arbitration in a particular place under a particular set of circumstances. And I'm going to give you several examples from real contracts of a sets of what are called boilerplate provisions. There'll be a provision dealing with often be a provision dealing with modification or amendment to the contract, how the parties go about amending the contract. There'll often be a provision dealing with assignment of rights and delegation of obligations. And we talked about that last week. We talked about assignment of rights and delegation of obligations. You'll see provisions from contracts, real contracts, dealing with those type of issues. There'll often be provisions dealing with attorney's fees. Who's responsible for the costs of negotiating the contract? And more importantly, if there's a dispute under the contract, who's responsible for paying the costs of that dispute, the legal fees involved, the court costs? There might be an integration clause. And remember, we talked about integration clauses. Integration clauses are clauses that wrap the whole agreement up into this written contract so that all the prior oral discussions that the parties might have had, even all the prior oral agreements, will be superseded by what's in the written contract that the parties sign. And that's what an integration clause does. There'll be a severability provision. Severability provisions are very important, particularly with contracts that are extremely complex and have many various terms and provisions. Severability allows the court, when interpreting a contract, if it finds that there's a provision that violates the law, that can't be enforced, it gives the court the option of either revising the provision to the extent that it becomes enforceable. So the court is given permission to reinterpret the provision to the fullest extent that would be allowed and would make the contract enforceable. Or if the provision can't be interpreted in an appropriate way, it can then be chopped out of the contract and dropped from the contract. And that's what a severability clause would allow. A severability clause allows a court to remove from the contract any provision that's unenforceable. Oftentimes, a contract in the boilerplate provisions will include what's called a force majeure clause. A force majeure clause, it's F-O-R-C-E-M-A-J-E-U-R-E, French word for meaning major cause, major force. And what that provision does is it excuses contract behavior, contract obligations, or suspends contract obligations when some type of disruptive, unanticipated, unexpected event occurs for which neither party is responsible and which neither party could reasonably have anticipated, and it prevents one or both of the parties from performing their obligations. A force majeure event is an event that allows for some either suspension or termination of a party's obligation under a contract. Oftentimes there'll be a provision in the boilerplate for notices, telling the parties how to get in touch, how to deliver notices to the other parties to the contract. And then the parties, the final part of the contract will be the closing of the contract, the closing provisions, where the parties sign the contract, where the parties provide any witnesses that are necessary to the contract, and that is the end of the contract. Now, there might be some exhibits to the contract if the exhibits are referenced in the agreement, where it's easier to put certain provisions in an exhibit as opposed to including it in the agreement. There might be certain types of schedules of factual matters that need to be attached to the agreement. But by and large, most contracts end with the closing of the contract and the signature pages. So that's the end of our discussion of practical contracts, of the terms of a contract, of the actual parts of the contract. And as I said, you will find in Canvas several additional contract forms, contract samples, and sample provisions so that you can see from real contracts what some of these provisions look like. I hope that this discussion has been helpful. I look forward to our last discussion, our last chapter, Chapter 14, Sales. We are going to talk about the Uniform Commercial Code, Article 2. That's Chapter 14. That's next week. But let's get through this week. Let's have a good discussion about contracts, the practical issues relating to contracts. And if you have any questions, please feel free. Email me or raise it in the discussion that we'll have this week. Thank you.